Good afternoon. We are on the record in the presence of the jury. Mr. Bahena is present along with the attorneys of record. Juror number 2. Do I understand correctly, you were selected as the foreperson in the case?
That is correct.
And Mr. Foreperson, has the jury reached a verdict?
Yes, Your Honor.
And is the verdict unanimous?
Correct.
And has the foreperson, have you signed the verdict form and marked it in accordance with the verdict?
I have.
With that record then, sir, I would ask that you hand the verdict to the court attendant, please. At this time, Mr. Bahena, I'm going to ask that you rise along with your attorneys, please. And I would ask that the court attendant read the jury's verdict.
We, the jury, find the defendant, Cristhian Bahena Rivera, guilty of the crime of murder in the first degree.
Thank you, Carrie. You may be seated, please. Juror number 1. For the record, is this your true and accurate verdict?
Yes.
Juror number 2. Is this your true and accurate verdict?
Yes.
Juror number 4. Is this your true and accurate verdict?
Yes.
Juror number 6. Is this your true and accurate verdict?
Yes.
Juror number 8. Is this your true and accurate verdict?
Yes.
Juror number 10. Is this your true and accurate verdict?
Yes.
Juror number 14. Is this your true and accurate verdict?
Yes.
Juror number 19. Is this your true and accurate verdict?
Yes.
Juror number 30. Is this your true and accurate verdict?
Yes.
Juror number 32. Is this your true and accurate verdict? Juror number 38. Is this your true and accurate verdict?
Yes.
Juror number 48. Is this your true and accurate verdict?
Yes.
Before I release the verdict, anything else on the record in front of the jury? Mr. Brown.
No, Your Honor.
Freezes?
No, Your Honor.
Okay. Thank you very much. On behalf of the state of Iowa, this completes your service. Carrie will take you back to your jury room. Thank you. Please be seated. We're still on the record. Outside now, the presence of the jury. Mr. Bahena is present along with the attorneys of record. The court has 3 things it wants to address and see if there's anything else we need to. Number 1, we will order a pre-sentence investigation report to be prepared and submitted by the 8th Judicial District. Number 2, no bond pending sentencing. And 3, sentencing will take place at 9:30 a.m. July 15th, 2021. Sentencing will take place in Montezuma, Iowa. Mr. Brown, from the state of Iowa, anything else we need to address on the record?
Nothing further, Your Honor.
Freezes, anything else?
No, Your Honor.
With that then, we will close the record. Thank you.
Y'all ready? Okay. You want to start asking your question, Lloyd?
Fire away.
Give us your reaction to this verdict.
We're disappointed. We respect the jury's verdict. They took a lot of time to come to the verdict. We wish it would have been different, of course, but they certainly came to their decision. We respect that decision. We'll explore our options now post-trial and go from there.
How difficult of a case was this from a defense perspective, considering he admitted to having Mollie Tibbetts' body in his trunk and the DNA was there?
Very difficult, of course. I mean, anytime you have a client who gives a statement like he did, and the fact that there was DNA evidence in the trunk, and the fact that he led them to the body, I mean, it makes it extraordinarily difficult. Absolutely.
Considering the statewide attention to this, are you, I'm trying to think of how to put this, but are you convinced that it was ever possible to find a jury? Do you believe they were impartial here?
In this case, we're very pleased that the jury took the time that they did to look at the evidence and to deliberate in this case. You know, it would be impossible to find a jury that hadn't heard about this case, and that wouldn't matter even if we had the ability to leave the state of Iowa. We would, which we don't, but we wouldn't be able to find someone, a group of people that haven't heard from this case. We're really pleased with the time that has been spent with jury selection and the time that was given to this case. So we're disappointed with the outcome, but that's what it is.
What are those potential options for you that you're mulling at this point?
Well, of course, we'll look at post-trial motions. We'll go back and look at any evidentiary issues that were raised during the trial. And of course, we had that issue on the motion to suppress that was litigated prior to trial, and of course that'll be looked at on appeal.
It's no secret that we disagreed with Judge Yates's suppression ruling. We sought discretionary review with the Supreme Court, and the Supreme Court denied that. Because we will file an appeal on Mr. Bahena's behalf, the Supreme Court will have the opportunity to review those claims and to make a decision.
Do you have an estimate on how long it will take to file that appeal?
Well, the sentencing's on July 15, so we have 30 days from that day. So you're looking at end of July, first part of August.
Can you talk us through the decision to have your client testify?
Well, the decision to have him testify wasn't as difficult as a lot of people want to make it sound. I mean, we had a situation where a client gave a statement, and he had her DNA in the trunk, and he led him to the body. That's all pretty incriminating evidence. And from the very first day we met Mr. Bahena, the story he put forth on the stand was exactly the version of the events he told us going back to August 2018. He had never varied from that version of the events, not one detail. So we had to get something up there, and we thought the jury needed to hear directly from him, especially since they couldn't judge the credibility of him on the video since it was in Spanish. And we had real issues with that interview and how it was conducted. So it really wasn't that difficult of a decision for us.
To clarify, did you say that the account that he gave on the stand is an account that he gave to you in 2018?
Absolutely. He has never varied from that, not one detail.
You know, I think there was speculation that we made some sort of, let's figure out a story. And I mean, if we were going to make something up, we would have came up with something better than that.
Do you worry that it didn't sound credible to the jury?
You know, just the story of Mollie Tibbetts' abduction was a bizarre story in and of itself. So what we thought is that whoever told the tale, whatever tale it was, had to sound credible. And the version of the events given by Mr. Bahena, it had to sound credible coming out of his mouth, whatever it was. So we were more concerned about how he appeared to a jury and how he sounded to a jury. And we didn't spend a whole lot of time preparing him. We wanted him to seem authentic rather than coached. And so we didn't spend, an inordinate amount of time preparing him to testify. We kind of just let him tell his story in a very genuine fashion. So what you saw from him yesterday is really who he is.
One thing that we can agree, and I think everybody can agree on, is that Ms. Tibbetts was someone that did not deserve to be a victim. And the fact that this woman went out for a run and ended up in this cornfield is just bizarre on its own. She was not the type of person that would engage someone in an argument. She's not the type of person that would be hurtful. I think that her choice, even if she thought something bad, would be to be kind. And it doesn't, I think any reason that someone would abduct her and leave her dead in a cornfield is just a bizarre set of facts, no matter what.
You worked throughout the case, or throughout the trial, to point fingers towards Mr. Jack's boyfriend. Is that, in your mind, the most likely?
He certainly gave us reason to suspect. Okay. There's a lot of people in this case whose stories didn't check out well enough for us. And that was a problem for us. So can we tell you who did this? No. We can tell you that getting to know Cristhian Bahena, we are very surprised that he would be the kind of person that would commit a crime like this. He is nothing but a soft-spoken, respectful, kind person. And every person we have talked to in the last 2.5 years who has had any interaction with this man echoes that. He's been a delight to represent from a legal standpoint, from a lawyer's standpoint. Has been absolutely no problem.
And another thing I'd point out is his family has been just a delight to work with. I know that there has been some questions from some of you about whether or not his family or why they haven't been at trial. These people are hardworking people, and I will tell you that whenever we meet with the family, we normally have 7 or 8 people in the room that care for him. And these are all people that work hard and have been following this case very closely. The fact that you all have been able to provide this to the public so easily has been beneficial. That this family, they just don't have the resources to take off 2 weeks, but they've been watching closely. We'll be in touch with them as soon as we leave the courthouse, and it has been a pleasure to work with the Bahena family. I have no unkind things to say about any of them, similar to how we feel about the Tibbetts family.
It sounds like you're intending to remain his attorneys as he goes through the appeal process. Is there any thought at this point to bring on any additional lawyers to the team?
Not at this point.
You mentioned during the trial when you were, I believe, cross-examining or examining Dalton Jack about phone records. Those, to my recollection, weren't introduced as evidence. Did you have those records? Were you planning on introducing them? If so, why not?
Well, there's evidentiary issues as far as the rules of evidence that don't allow you just to introduce phone records. We did have those phone records. They were about 5,000 pages in length. What we wanted to use them for more than anything was to point out inconsistencies in his story, or stories, I should say, and how it was just kind of a head scratcher to us how he could not recollect the days leading up to his girlfriend's homicide, and that was a problem for us.
Also during your case, you mentioned the unknown DNA, the unknown fingerprints. Are there plans, or are you able to independently test any of that on appeal?
The problem is if we don't have a buccal swab from somebody, it's pretty difficult to do that. There are times that, there's databases that certain people, that are compelled to give a DNA sample. But, if my DNA were in something, or probably yours, it just isn't going to be there. And with this case, again, with the Tibbetts family and with the Jack family, I don't think we have any reason to believe that unless, we had their buccal swab, that it would show up on some sort of a database.
Is there any other evidence that you wish that you could have brought out in the case that, or that maybe you were on the fence about bringing out? What were some of the considerations there?
Go back and look at our motion in limine, and I think you can tell from that. I'm not going to speak any more on that today. But look at our motion we filed right before the case was heard. Our resistance to the motion in limine, I think, will speak for itself as to what we would like to have introduced. There's been other motions filed throughout the case that talked about other evidence that you didn't hear in trial, but I think speaks to perhaps why we were so intent on going after one witness in particular, Mr. Jack.
What about the two masked men? Were efforts ever made to locate them?
It's like trying to prove there's not a Santa Claus. We don't know who those persons could be. Remember, our client lives really out in the middle of a very rural location. And we kind of tried to link it up the best we could through the people who we thought would have some sort of motive, and that's where we went with some of the testimony, but that's very difficult to establish.
We're fast approaching 3 years since this happened. Do you think timing of this trial played a part in some of the witness testimony and the verdict today?
A little bit. I think it also helped to, as far as 2018 was a much different time than we have today. 2018 was, in my opinion, very conflictual, very difficult time for an immigrant. If we'd have gone to trial within 90 days, like a speedy trial right would have allowed him to have, I think it would have been very difficult for him. I think the passage of time has allowed some of the pain to heal a little bit, let all of us kind of just take a breath and be a little more pragmatic in our decision making.
We don't want to keep the family and everybody, so maybe one more question.
They said it'll be 10, 15 minutes.
Okay.
Can you explain Mr. Bahena's, status as far as citizenship or immigration, or how his status, does he stay in the country until appeals are exhausted, or do you have a sense of that?
He'll serve whatever sentence he receives, and then they'll take care of that issue.
You good?
All right. Thanks, guys.
Thank you for
Thank
being
you.
with us. Thank you.
Thank you so much. Appreciate it.
Safe travels back.
Thank you.
Same to you.
There we
You're
go.
not going in?
You're not stuck in here with us for a second or two.
Right up here. Okay, everybody, go ahead.
How does this decision feel for y'all?
Go ahead.
We feel great. I mean, this was the verdict that we wanted. It was the verdict that the evidence demanded, and it's great for all parties that justice was served.
What does this mean for the family? Have you been in contact with them after this?
Yeah, we just spoke to the family for a few minutes afterwards. They're relieved. They're pleased with the verdict. it's just the family of Mollie Tibbetts is just a great bunch, and they've been awesome to work with in this circumstance. Of course, it's always very tragic, and whenever something like this happens to a family like them or any family, and they've just been very supportive of everything we've done, and we just wish them the best and moving forward.
Why do you think y'all won?
Well, I mean, you sat through the case. I mean, the three core elements of our case had to do with the surveillance video that captured his car right when Mollie ran through, the defendant's confession at the sheriff's office on the 21st of August, and kind of cinching all that up is Mollie's blood being found in the trunk of the vehicle. So I mean, that was those were all critical parts of it. So I'll give any comments on it.
No, I think that's what did it. And the big thing is that he knew where the body was, and that was a big piece of the corroboration to his story.
Yeah, if you guys remember, the leading us to the body at 4:30 in the morning, that was part of the pretrial order, that we couldn't bring that up initially, but once he took the stand, that kind of removed all of that, and we were able to bring that up, and did with him on his cross-examination. So
tell us about when he was on the stand. What was going through your mind?
You want to take that one?
Sure. Well, it was one of the possibilities that we discussed that could happen, but it was a little surprising, I guess, to me what actually was said. It was completely inconsistent with the version that had come prior, had weaved in some of the details of the actual case, but again, because it wasn't the truth, there were pieces that didn't match up to what had actually happened. So, that's tough, sitting through a third version of what had happened when we think we know what had happened based on our investigation. But the jury heard that, and the jury made the right decision.
Were you surprised when he stood up?
Surprised by?
See him on the stand.
As the trial went on and as our evidence came in, I was less surprised. At the beginning of the case, we had this discussion about whether or not he would testify. We're always ready for a defendant who testifies, we're always ready for a defendant who would testify, to prepare for it, I mean. And we thought at the beginning, maybe it's not likely, but as things went on, as things kind of came in, we thought very well for us. Our witnesses did well. We thought it may be more likely that he takes the stand. So we weren't expecting the story that he gave. Like Bart had mentioned, we didn't know what it was going to be until he opened his mouth and started talking about it. So, but yeah, I mean, less surprised, I guess, as we went along that he took the stand, and we were ready to cross him whenever that happened.
Were you worried that him giving a completely alternate story would confuse the jury, that was maybe, leaning this way prior to him talking, and that maybe that kind of made things take a little longer in deliberation?
I don't know. I mean, when a defendant gets up on the stand and starts adding in like two phantom people, which is what he did with these two guys that are completely covered in stocking hats that he can't identify, he removes all the ability of anybody listening to what he's saying to identify who those two people were. We think they're figments of his imagination, just as we argued, but he covered them head to toe, and then there's no vehicle. So what are the two chief ways we're going to identify somebody like that? Facial features, possibly tattoos or other body markings, and what vehicle they might drive. And he totally removed that from that story. So, in that sense, he provided us no ability to confirm or deny the identity because he didn't provide enough information that would allow us to confirm or deny it.
Do you think him coming up to the stand and telling that story that a lot of people found implausible helped your case?
That's the way we argued it, certainly. Whenever during rebuttal yesterday. So yes, in that sense, to answer your question, I think it ended up helping us. I mean, he's coming up with something totally new. he had a chance to tell that same story if he was truly fearful for his child and for Iris. He put them into the mix. He never told the police that. He's in one of the most secure facilities in the county whenever he's talking to the police about what happened, and he doesn't bother mentioning that. I can't imagine that helped him too much.
If he had given this story of the two men when he was first interviewed, how do you think that would have changed the course of the case? Would there have been different investigations? Do you think he would still have wound up under arrest?
Go ahead.
Well, certainly he did admit to concealing the body, and that's a crime in itself, but there would have been additional investigation to find these two individuals that he claimed were there. I mean, the officers involved wouldn't have ignored that. But that's something that was omitted from his first version. His first version, when he said that he had seen Mollie in all the evidence that was presented at the trial, that was a complete and coherent story, and that's what the investigators followed. And if it had been something different, the facts had been different, they would have followed those facts.
To do the buccal swabs that the defense accused the investigators of not collecting in their closings and throughout the case, what happened to them? Why weren't they collected?
The collections that were done at the at Yerby Farms.
Where it says the broader neighborhood canvas, I think they mentioned Ron, those alternate persons of interest. Why weren't they collected?
Well, there was no reason to collect them, and in my estimation, I think Bart's as well. If there would have been, we would have sought a warrant to get it. The other people that they raised as potential suspects, I mean, literally, as I argued, were literally run to the ground. They looked at them, they examined what opportunity they would potentially have had. They're looking for anybody, any other suspects, any other leads. That's what investigators do. When we got the break with the vehicle and in the video, thank goodness the two agents that were watching that video saw the little shadow go across the back of that frame. Had they not seen that, I don't know where this case ends up. I mean, I would tell you the police investigation, even though it was heavily criticized by the defense, I think our investigators did a very good job in chasing the leads that were there. Agent Valletta, Agent George, Agent Reeson, there's lots of other agents that were involved in this case, some of which you heard from. They were persistent. I mean, this is a grueling process for them, particularly when they have the shine of the media is on this case from the very beginning, and they were able to do their job despite all of that, and just keep looking and just keep trying. And they got fortunate with this video, but a lot of times in cases like this, that's what it takes. And it's not that they're lucky; they're persistent. They do their jobs well, and they should be applauded for getting us to this spot. These cases don't happen. These convictions don't happen without good, competent, more than competent, excellent investigators that we have with the Iowa Division of Criminal Investigation, our local law enforcement in Powesheik County, all the other assistants that we had with the FBI and Homeland Security. We were criticized for that in the courtroom, but if this was your loved one, if this was your daughter, if this was your son, wouldn't you want us to do that? Wouldn't you want those types of resources to be deployed and to be utilized? I certainly hope so. If it was my child that was missing, I would hope the state and the federal government would pull out all the stops to figure out where they are, help us find them, and figure out what happened to them. And if it's a violent end to their life, figure out who did it. That's what happened here. And I think the officers in this case and that worked this should be applauded for their efforts and their persistence and their expertise in helping us get to this point.
A question for Mr. Klaver. You, I think, were only became the Powesheik County attorney a few months before all of this happened. Can you just speak to being, still fairly new in the job and having a case like this drop in your lap?
Well, in a county as small as Poweshiek, this doesn't happen. I don't think it's common necessarily anywhere in Iowa. But, Scott came down to Brooklyn very early on in the case and was a big help. And so he's shepherded this case nearly from the beginning. And so it's something I had a lot of assistance with.
Was there any time in the past 2 weeks that the thought might have crossed your mind that this case could have gone the other direction?
Yes, of course. I mean, I've not slept a full night. I don't think Bart has either. You're always worried what a jury's going to think of this. So, I mean, yeah. I mean, it's, you should ask my wife about some of the phone calls we've had in my sleepless nights. But it's just, it's hard to get through it. I mean, and it's, you're thinking about it constantly. But I would tell you, I mean, this case is not about us. It's not about me. It's not about Bart. It's about Mollie Tibbetts and her family is who we've been working with this whole time. They are the ones that have to live through this. And, this is our job. We'll be done with this case soon, and we'll move to the next one. That's what we do. With the family and other people that are that close to it, I think you just got to keep in mind that, they live with it forever. And, we understand that. That's why we hope that in the end of when these cases are over, we can bring a sense of justice to them, even though we would never have the ability to bring Mollie back. We hope moving forward that they know the person that did this to her is going to be held fully accountable.
Can you tell us what it was like in the room now with them? I know you met with them in the overflow room right after the verdict. What was it like in there?
Go ahead. Emotional, certainly, and I think also a sense of relief is how I would describe it. I mean, this case has been going on for quite a while. It's been continued for various reasons, and certainly from COVID. But to get to this point, it's been a long time coming, and it's like a weight, I think, off of everyone's shoulders. And to get the result that we did also is, I think, punctuates that a little bit more.
Even with the outcome that you hoped for, is there anything from this case, this process, you'll take as a learning opportunity?
Yeah, I think I've been doing this quite a while. Every case I learned something about something that I did or didn't do, or how we present something. This was the first time, actually, that I've had what is a completely digital case in the sense of we didn't have hard copy photos or exhibits. Everything was scanned in. It's on a flash drive. It's on a computer. I have used digital presentation software before for quite a while to put pictures up and things of that nature, but never kind of a paperless trial in that sense. And so that was a little bit of a challenge, and I'm glad I could get through it that way. But yeah, to answer your question, I mean, certainly we learn from a lot about how to present a case, how to make it a coherent story for the jury, to make it compelling. I mean, whenever we set out on cases, we obviously want the jury to convict. I mean, that's why we're there. We filed the charge and we have our proof that we believe is there beyond a reasonable doubt. But and we certainly want to be orderly in how we present that story and make it a compelling story for the jury. So ultimately we can gain a conviction at the end. That is what we're after. That's what we think.
Motion, also, possibly looking for anything else in the trial that they disagree with. Can you just speak a little bit to what you think the prospects for that are and how you expect that might play out?
Well, I'm not really sure, I guess. I mean, the fact that he testified, so all that information, or at least the part between the sheriff's office and the field, came in, so that removes that appeal issue, I think, at least to a certain extent, from that suppression order. I don't know if there's anything else that was that would be appealable. That it'll be appealed. I mean, we know that. It's automatic in these cases, and that's. I don't know what those would be. You'd have to ask the lawyers that handle it. I don't know if it'll be the freezes or if it'll be somebody else, but I'm not really sure. They'll go through it with a fine-tooth comb like they always do. So I'm sure we'll have something.
The defense did tried to bring up the P word polygraph during the trial. Did Dalton Jack pass a polygraph?
I'm not really going to speak. He passed it in a sense of it passed? It was inconclusive was the result. But let me just tell you about polygraphs. They're inconclusive. We get that a lot on whenever polygraphs are that's the result. It doesn't mean anything. That's the whole point. Polygraphs are not admissible in court for a very good reason, and he could have been nervous and talking to the police. He could have not been feeling well. There's all sorts of things that factor into that. That's why they're not admissible. And so the fact that there was some sort of result like what I just described really does mean nothing in our mind. And, there were a number of people that were, where they utilized that tool that it comes back that way. So I really don't think there's anything with regard to that result that anybody should be concerned about, or that we were hiding something from anybody. We would never do that. It's just not admissible, and there's reasons it's not admissible. So.
Yeah, and just to anyone who feels like there's suspicion on Dalton Jack, or that the defense, tried to cast suspicion on him, what do you say to those people?
Dalton Jack did not do this, okay? Let's just put that out of everybody's mind, okay? He was working construction in Dubuque with Jasper Construction. Dalton Jack did not do this, did not commit this murder. He was raked across the coals at trial. I thought he actually handled himself pretty well. He didn't do it. He didn't behave like a person who did it. He was not anywhere near Brooklyn on July 18th of 2018. He was distraught the next day. His boss ended up letting him go home because he could not find Mollie. If somebody like that would have committed this crime, why would they want to go anywhere near Brooklyn, Iowa? Why would they ever want to go back? Why would they ever want to have it, they would want to stay as far away from there as possible. So, yeah, put that out. I would like people to put it out of their minds. Dalton Jack didn't do this. He was vetted. I guarantee you he was vetted. That just like Agent Valletta described at trial, we start with people who are closest to Mollie. He was closest, well, other than maybe her immediate family, he was closest to her. He was interviewed. He was vetted. They picked through his background. Some of that came out at trial. And I can tell you from looking at all this, he did not do this. The person that did it was convicted. So they want to make Dalton Jack another suspect. That's what they tried to do. It didn't work. And it didn't work because there's no evidence that supports it. That's why. So, yeah. We're done?
Any other questions?
Okay, guys. Thank you. We appreciate it. Yep.
Thank you.
Thank you, Mr. Brown.
Thank you. No.
Go down.
No.